Good afternoon, everybody. Welcome to the Department of Justice Elder Justice Initiative webinar, What Data Reveals About Administering Capacity Assessments. Due to the high number of participants, computer audio will be the only option to listen to the presentation. So please make sure that your computer speakers are on. This webinar will be recorded and available on the Department of Justice Elder Justice Initiative website after this training. Closed captioning is provided in the pod below the presentation. If you are having issues viewing closed captioning and you do not have the Adobe Connect app installed on your computer, please close out of this meeting, download the Adobe Connect application, and then rejoin the webinar. If you do not wish to download the app, close out of the webinar, make sure Adobe Flash is enabled on the web browser such as Chrome, and then rejoin the meeting. Then you click on the link and join with the classic view, and then you will be able to see the screenshot there below. If you have any technical issues during the webinar, you can communicate with me in the chat pod. Now I'm going to turn this over to Shelley Jackson, consultant to the Elder Justice Initiative. Welcome, Shelley.
Good afternoon, everybody, and thank you for joining us today. My name is Shelley Jackson. I'm a consultant with the Elder Justice Initiative, and our mission is to support and coordinate the Department of Justice's elder justice efforts. And we do this by promoting justice for older adults, helping older victims and their families, enhancing state and local efforts through training and resources, and supporting research to improve elder abuse policy and practice. Next slide. And we'd like to invite you to visit the Elder Justice website at elderjustice.gov, where we have lots of information and resources for busy professionals. We've got resources for multidisciplinary teams, prosecutors, law enforcement, and other professionals. Next slide. Okay, and now I'd like to have you join me in welcoming our speakers today. We've got Sara Qualls, who is a professor of psychology at the University of Colorado, Colorado Springs. And Sara's going to be discussing the results of a study they did in connecting Adult Protective Services referrals for capacity assessments to actually administering those capacity assessments. And then I'd like to welcome George Demakis, who is a professor in the Department of Psychological Science at the University of North Carolina, Charlotte. And George is going to be describing his research conducting capacity assessments in the context of guardianships. So we're going to have our two speakers talk for about 20 minutes each. We're going to save 10 to 15 minutes at the end for questions. Of course, you're welcome to include, or throughout, you can put comments in the chat box, but we will be taking questions at the end of the session. So I have been following closely the work of both of these professors for years, and it's just my honor to have the opportunity to learn from them today. I believe that George is going to start, so George, I will turn it over to you.
Okay, well, thank you for that introduction. My name is George Demakis. I'm a psychologist. I work here in Charlotte, North Carolina, Mecklenburg County. I'm a faculty member at University of North Carolina at Charlotte. And I'm going to be presenting on some clinical and research work that I've been doing for about 15 years with a variety of colleagues here. Before kind of getting into the nuts and bolts of this, I wanted to mention a couple background issues. One, I am a psychologist, so there will be a bit of a mental health bent or angle to the presentation, and I will explain tests that have been used that are more psychological nature for folks that might not have that background. I also wanted to talk a little bit about terminology, and that's the distinction between capacity and competence. The title of this talk is about capacity assessments, and most states use the term incapacity to refer to someone who needs a guardian, for instance. However, where I practice and where I work in North Carolina, the term is actually competence and incompetence. So I will use those terms interchangeably, and I think that's a good reminder that I'll mention later, that you have to know the state you're practicing and the preferred terminology in that state. Okay, so I wanted to share with you 3 studies that I've done with colleagues over the years, and really addressing 3 questions. One is, who undergoes a civil capacity examination? Can you hear me?
Yes.
Okay, so cut out for a second there. Okay, so who undergoes capacity examinations? What are the outcomes of those examinations? And this would be in terms of whether folks are adjudicated incompetent or not. What are some of the factors that predict an incompetency adjudication? That's my second question. And then at the end of this process, if someone's adjudicated, there is the possibility for restoration. And my question here is, what predicts whether people get restored or not? Okay, a little bit of background. A capacity examination is an examination that assists the court with an incompetency determination and or a guardianship determination. Again, if you're working in a state where this is, the terminology is incapacity, you could say assist the court with incapacity issue. The ultimate adjudication, the ultimate decision is not made by the clinician, the psychologist, the nurse, the physician, but by the judge or in rare cases a jury. So your job is really to provide a recommendation to the court. The policies, procedures, criteria that govern these examinations are statutorily defined. This is particularly key with the definition for what constitutes incapacity or incompetence. And I think I missed one. Okay. Last point here is that for clinicians out there, these examinations are a little bit different than a traditional clinical examination in the sense that your referral is from the court, at least it was in these cases. You're answering a legal question. You're helping the judge answer a legal question. Is this person competent or not? It's a little bit different than clinical cases because in clinical cases, oftentimes the question is diagnosis, recommendations, treatment. Those are not typically part of our examination in a court referral. So a lot of similarities, but there are some differences. Okay, so here's the statute in North Carolina for incompetency, and this is an incompetent adult, someone who lacks sufficient capacity to manage their own affairs or make or communicate important decisions about their person, family, or property. It's really important to know this in the state you're practicing because this is the statute the judge or the jury will be using to make an incompetency determination or not. Okay. All right. Once someone's adjudicated incompetent, most states break guardianship down into three components. There can be a guardian of the person, which is to make medical, residential sorts of decisions for a person. You could have a guardian of the state, which is to make financial, estate decisions for the person, or a general guardian, which someone would make both of those decisions. In most states, once someone's adjudicated, they're called a ward, although the terminology does differ by state. Okay, and just where I practice, just to give you a bit of feel for this, when we're talking about the initial incompetency determination, the evidence there's a high bar. The evidence must be clear, cogent, and convincing. You have to be pretty sure that the person is incompetent, meets that statute, for the judge to say that person is incompetent. In contrast, when someone is petitioning with a ward, in North Carolina anyways, is petitioning for restoration, you don't have as high a bar. The bar is lower. The bar in North Carolina is the preponderance of evidence. So you can see the state is sort of encouraging folks, once they're incompetent, to seek restoration because the bar is lower. Okay, and this is just a cartoon, which is, what's the minimal level of competency around here? If incompetency is a high bar, which is difficult to get to, you need a lot of evidence to support that. to have competence, to have capacity is a lower bar. Okay, so as you look at the research that I'm going to be presenting, when you see an incompetency adjudication, you know that the judge has made that decision using a very high bar. Okay, so the steps in an incompetency adjudication typically begins with a petition. The person would be assigned a GAL attorney, which would represent their interests, and there's a whole background about this, probably don't have time to get into about different models for this. Hearing or set of hearings, there's an ultimate adjudication, and then there may be restoration. So that's kind of what the process looks like. And I have in here that the respondent, person who's allegedly incompetent, can retain their own counsel in addition to their GAL. They can request a jury trial, and they can appeal the decision. A jury trial in an incompetency hearing does happen where I practice. In 15 years, it's happened 3 times. So it's relatively rare. Mostly it's the hearing officer or judge making a decision. I had another, okay. Capacity exams can be done here at the hearing stages, at any step in here, or requested here, and can be requested at the restoration as well. Okay, so background information, the data that I'm going to be presenting on are cases from 2002 to 2018. These were all in Mecklenburg County, North Carolina. Okay. The capacity exam is the terminology I'm using today, but if you're practicing in North Carolina or you look it up, the technical term for these examinations is a multidisciplinary evaluation. And despite the terminology, these are really performed by psychologists. And the ones that I'm presenting today, the data that I'm presenting has all been presented by, all the exams have been done by psychologists. The demographic and clinical data that I'm presenting is all from reports, written reports that have gone to the court. And studies 1 and 3 use data from 8 different licensed psychologists, and study 2, I'm presenting only the cases that I saw personally. And there's, at the end of the day, the court adjudications in all these cases are publicly available from the courthouse. So literally you can go to the courthouse and find out what happened to the case that you saw. What was the ultimate disposition of that case? Okay. Okay. So first question is the first question is who undergoes a capacity examination? In a variety of different respondents. These are people responding to the petition that they're incompetent. The most common you can see are patients with neurological issues or psychological or psychiatric issues. I'll talk more about that in a second, what those patients look like. And this is about 350 examinations that I have the data on. Okay, so of these cases, of the ones that were seen over this time period, 85% were for incompetency and 15% were for restoration. So relatively fewer cases seeking restoration as compared to competence. And these are, again, all court ordered. Okay, what is the outcome of these cases? So of the incompetency cases, of the referrals for incompetency, 81% are found incompetent by the court. For restoration, only 35% are restored at that time. Okay? So you can see there is a tendency, especially in the incompetency referrals, for the outcome of the case to be the respondent to be adjudicated incompetent. Okay, the question about how the level of agreement between the judge or the hearing officer and the psychologist, you can see it's pretty high. Almost 90% in competency cases and about 75% in restoration cases. So what this means is that the psychologist's report is really influencing and affecting the way the hearing officer or the judge is reasoning about the case. We can talk more about that if people have questions about that. There's kind of a lot there, and I do want to get through the rest of the slides. So those are the kind of the basic data. So you can see there's a lot of folks with neuro issues coming through. There's a lot likely to be folks with dementia. Okay, I've broken down some select issues by type of respondent. I wanted just to focus on two issues. One is family conflict, and the other is financial issues. Family conflict tends to be more common in a mental health case. In a neuro case, the conflict looks different and surrounds different issues. In the neurological case, it's often surrounding money or estate issues. In the mental health case, it's often just around irritability. There may be paranoia or other mental health issues that affect the relationship between the family and the respondent. So family conflict is, let's say, less common in a developmental disability case. Financial issues, very broadly, are more common in neurological cases. These would be folks with dementia who have accrued some money over time, some land, for instance, and there's dispute about that amongst, let's say, middle-aged children. I should say that besides the last row in this table, these are things that I've observed in cases and my impressions. These are not quite empirical yet, so I don't quite have the data on this, but this is what I'm seeing in the cases that I'm working on. Okay, moving right along here, my second question was, what predicts an incompetency adjudication? This is a study I did with Dr. Emily Quickle, a student, and what we did is we looked at all the capacity examinations from 2004 to 2011, and these are just my cases, and I looked at the test findings that I obtained on my testing and the ultimate court decision to see which of those variables would predict what the court decides. My battery was sort of brief. It included the mini-mental state examination, which is a brief screener measure of cognitive functioning, is widely used in dementia. The independent living scales, which are measures of functional ability. So managing money has people, counting out change, writing checks out, reasoning about financial issues, health and safety. Subtest includes things like showing how you would dial the police, questions about how you would handle emergency situations and the like. So it's really more about functional abilities, managing day-to-day, as opposed to cognition per se. Okay, the respondents, missed that, okay. And you can see this is a little bit different breakdown because the sample is a little bit different, but I want to go to my findings. Okay, so of these three groups, the demographics were pretty similar. The neurological group, not surprisingly, was older than the psychiatric or developmental disability group. This kind of makes sense if you're working with folks with dementia or stroke. Okay. The psych group performed better on the cognitive measures and independent living scales. So they're cognitively and functionally not as impaired. And this is, I think, the important point of this study is that the independent living scale, which is a measure of functional abilities, activities of daily living, actually predicted the judge's decision better than the cognitive measures. So it seems like, and if you think about that, the statute, it's talking about managing your own affairs. So the degree to which we tap into that to the test are the degree to which we can predict what the judge is going to do and, in fact, help the judge. We'll talk more about this in questions, but just that the functional measures do better than cognitive in predicting judicial decision-making. Okay, final study here is who gets restored, what predicts restoration. This is a study I'm doing right now with 53 wards who have already been adjudicated competent who are now petitioning for restoration. This is over that 16-year period. And again, I did a lot of the same things, looked at the reports, went to the courthouse to find the disposition of the case. Okay. Of those 53 cases, 35% were restored, 57 were not restored, and some of these files were just missing. The courthouse couldn't find them. But this is, again, goes to about a third of folks who petitioned do in fact get restored. A variety of folks seek restoration, as you can see. Women and folks with higher education were more likely to get restored, but interestingly, there were no differences in diagnosis about restoration. So people with mental health issues were just as likely to get restored as people with neuro issues. And there was no differences, surprisingly to me anyways, no differences between cognitive functioning and actual functional abilities, ADLs, in restoration versus non-restoration cases. And I want to say that very little research on this topic. There's maybe a few studies. Most of them come out of more of a legal tradition and are reviews of cases and case law as opposed to actual empirical data. So those are my three studies and three questions I've asked. I wanted just to offer a few caveats. One, this is one county in one state. We had 8 psychologists here, but 2 of us did the vast majority of the cases. So our opinions and our data is overrepresented. I would have loved more cognitive and functional testing, would have loved more data on the context of these evaluations, so family data, social data, context would have been great. That's sort of hard to do when you're working with lots of different examinees with lots of different evaluators. And so just thinking what's important for doing a capacity exam, this is maybe going a little bit beyond the data, but not entirely. So just know the state statutes, you're working in the case law if there is case law. This next point goes back to the second study. Ideally, tests that map on the state statute are preferred versus ones that don't map onto it. So if your state statute is really talking a lot about ADLs, activities of daily living, you really should be assessing those in your workup. Ideally, this is not just about tests, even though that's what I focused on, but it should be about the real context of the person, context of their life. Family conflicts and dynamics, really important to examine. Don't have a lot of good empirical data on this. You're going to be, in my practices, people from all over the world, all different religions and nationalities. So understanding how these cultural, SES, and religious factors combine are really important because they address how, especially with the elderly, how people take care of the elderly, their expectations for the elderly, and so on. So understanding that is important. And I would say this is my last point. Didn't have time to get to guardianship, but guardianship, understanding people that you're recommending for guardianship if it comes to that, and ideally the fit between the guardian and the potential ward are really important. I have included several references, recommended readings below that go into some of these issues in a little bit more detail than I could today, especially the guardianship piece.
Thank you, George. I think now we're going to hear from Sara.
That's great. Thank you, George, for what you shared. We do need so much more, so much more data. I'm going to share today some findings that we had from a community-based project in which we were attempting to create an integrated care model between adult protective services and a capacity evaluation provider. The context here is, first of all, that across the country, APS agencies report that they really struggle to identify and engage evaluators. Their demand is much greater than the number of people they can access to help them with the assessment. So we were asking questions like, what are the logistics problems that are inherent in this type of practice, and what strategies and solutions can be used to address them? The problem might simply be a workforce pipeline problem, but might also be a context of practice. There may be context of practice issues. So the context for this particular project was the University of Colorado Springs Aging Center, which is a mental health services and training clinic that has provided neuropsych evals and been asked to do capacity evals for over 20 years at this point. We've partnered in delivering mental health services through this training clinic, and we have a professional staff as well, with many safety net organizations in addition to APS, including the federally qualified health center, the PACE program, the nonprofit hospice, et cetera. So we have a lot of experience with partnerships and with initiating and integrating mental health into a variety of settings. So this was an expanded geriatric mental health services project that had multiple pieces, but the goals I'm going to talk about today are the ones that relate to capacity evaluations. So first, the first goal was to really try to figure out the scope of need. We were hearing a lot about how how APS needed more and more evaluations, and they couldn't afford them on the private market always, and so they were they were scrambling. So we wanted to figure out, well, what is the scope of need if you define it by what you can saturate, if you can throw all the money and resource at it that you have. So our second goal was to really focus on process variables that shaped the success or difficulty with the implementation of this kind of an integrated program. And then thirdly, of course, always to try to figure out what would be the sustainability plan once you take away the grant funding. So I'm going to organize this talk into logistics challenges and some recommendations and some outcome data. So the first logistics challenge in almost any integrated care setting, and it turned out very much to be true in this one, focused on the referral process. So typically, APS was sending referrals that would say, assess capacity, which seemed very reasonable from their end. From the side of the evaluator, that doesn't provide enough information to support the evaluator in figuring out what battery do they need, how much depth is going to be needed, is this going to go to court, which capacities is not an all or nothing factor, so which capacities are going to need to be evaluated. So you can see in the first red box, our solution was to create a checklist of capacity questions. We worked with APS to identify their most common, gave them a checklist, and then in the second white box you can see, unfortunately, what we got was that everyone checked everything. And so that didn't give us any better discriminatory ability to prepare for the evaluation. Could it be done as briefly as what George was describing, with a very brief cognitive screen and a functional assessment, or did it need a more thorough evaluation? So we then moved into a process of interviewing. The evaluator would call and actually talk to the caseworker who knew the case and had more background information on some of those contextual variables that George was mentioning, as well as the functional questions that were really critical. So that led us to a process in which an evaluation plan could be assessed once the context of the question and the key domains of concern were identified. Obviously, a referral process that involves that kind of interview process takes more time, and the logistics of just simply getting those two people to connect in a timely way on an urgent evaluation are not trivial. A second major logistics challenge for evaluators comes around records management. Almost always APS has a sense of time urgency. There are safety issues and they need this evaluation done quickly, and there are often very substantial challenges in obtaining background information and medical records in the complicated cases that they are handling. So issues, there may not be any records. This person may not have seen a provider in 20 years. Or there may be a question about who can provide the record. Is this person his or her own decision maker currently? Can he or she provide the information needed to even find the records that are relevant. And in cases, keeping in mind we're an aging center, so we see people over age 55, what that means is that almost all of them have complex medical conditions as well as psychosocial challenges. So in cases where the person or the collateral is uncooperative or incapable, it really makes record management a really significant challenge, and yet getting that good picture of the medical and biopsychosocial context is critical for making a decision about someone's true capacity to function independently as separate from their ability to function in the current environment under the current conditions. A third logistics challenge for us was to adapt our practice setting. So keep in mind we're a training clinic. We have a relatively slow fluctuation, slow volume of clients coming in and out. It's in a very pleasant environment. And now what we find are that scheduling and dealing with pragmatics in the practice setting become a significant issue as we're adapting to this unique clientele and this partnership with APS. So for example, APS gives us a predicted referral rate, and we schedule accordingly so that the neuropsychologist is available for certain kinds of Medicare evaluations on other days, and then they have their APS days. Well, when the fluctuation rate, when the referral rate fluctuates, that really makes it challenging to use that person's time and to fund that person consistently. Really high rates of cancellation and postponement. I think the record in our clinic might be that one case took 34 separate phone contacts and 3 or 4 postponements to get the person actually in for an evaluation. Again, these are people living in fragile situations with fragile health and fragile health. And so often they can't come or don't come on a given day. Arrival without a support person, lunch, or a transportation plan, huge issues in a practice setting. So having an agreement became a critical issue for us between us and APS about how that was going to get handled so that those issues didn't get dumped on a professional in our setting because they hadn't been prepared for ahead of time. Many people who are needing to be evaluated, especially older adults, can't tolerate an assessment in a single session, and yet they aren't very likely to return for a second session. Again, if they're uncooperative or unable to see the purpose of the evaluation or resist it. So how do you choose what you put in the first session so that you get your most critical information in case you don't get the second session? And then how does that influence the certainty with which you can make a clinical judgment? Even the lobby became different. There were significant behavior challenges in some of the APS referrals that really required some management, and other clients coming in and out of the clinic were not always comfortable with sharing a waiting room, even with people with significant behavior challenges. So when a staff person was added to accompany the person and therefore help manage those behavior challenges, now you've got more volume in your waiting room because you have a patient and a staff person. So just practical things. Another challenge, of course, and a big one, is payment. There are all kinds of legal and compliance issues that you have to deal with when you're going to evaluate a person where capacity overlaps with health condition. So the referral may be, does this person have a diagnosable condition? Well, that's a health referral that can be billed to Medicare. If it's a question, and everyone knows it's a question of capacity that's going straight to court, and that's the primary purpose of the evaluation, then it cannot be billed to Medicare. So sorting out and getting a very firm policy in your clinic about how you're going to handle legal and compliance issues related to Medicare compliance and related to the ethics and legal standards of the field are important. We knew from the get-go that our project could not manage, that APS could not pay for all of what they needed. That's why we got the grant funding. But we also set it up where APS paid a very low fee so that we could try out a reduced rate for APS as a potential sustainability plan. So if we made a separate agreement for reduced rate, then what happens when the grant funding ends? Can we actually sustain the professional staff on that budget? The answer is no, but I'm getting to the chase. And then time estimates. Payment relates to how much time it's going to take to do the evaluation. And so we had made estimates in writing the grant proposal based on an assumption that we would be doing an assessment that took about the same amount of time as an existing well-reputed provider in town. And yet the standards for competency or capacity evals have really shifted over time. And so the time estimate we made did not allow for enough time to do all of the different components of what's recommended by the APA and ABA in a capacity evaluation. So that affected our whole payment picture. Okay, with those challenges in mind, I want to make some suggestions of what we take away from our project about strategies for success for another organization that might be trying to put together some kind of a partnership between APS and a capacity evaluation provider. First and foremost, you need to understand the organizational context of your own organization, whether it's APS and or you are representing the provider. The budgets of both organizations for evaluations are critical. How much time does it take? What's the billing rate of that time? And how much is available within the APS budget? Which in most states, those budgets are the same as they were, years ago. They've not increased with the amazing increase in volume, especially in states that have mandatory reporting. So that volume has really escalated without increased budgets to compensate for that. So it's a big issue. So you need to be realistic about it. We also that there were attorney requirements within APS for how they wanted their petitions to be processed and what they wanted in the evaluations, and those needed to be understood. Staff turnover rates tend to be quite high in APS. That's of great relevance if you're trying to work out integrated care. As I know, processes as simple as sending referrals, how you actually communicate that you have a referral. Is it centralized, all handled through a manager who understands the other organization, or is it distributed so every time a case manager's role, staffing shifted in that position, that person now, the evaluator team has to start over with educating that person to get the referrals to come in a way that makes sense and do the interview process. Same thing on the evaluator side. What are the current standards for practice? What are the evaluation needs? How are you going to handle referral scheduling and records request? The probate judge is also a relevant factor here. In the 36 years I've practiced in Colorado Springs, not as an evaluator, by the way, I do family work, but I'm a researcher. The probate judge here has changed many times, and each time it tends to be a person who does not know guardianship law and guardianship practice, and they have to train up, and they do. And we've had great probate judges in my county, and they each have a preference. You need to understand the organizational issues for them. So I would say that one of the recommendations that comes most strongly out of our team is to invest in cross-training. We actually allocated time for our aging center staff, psychological psychometrist or neuropsychologist to attend APS staff meetings, to listen, to understand how our work was making their jobs harder, and to share with them how neuropsychs or capacity evals are done. Most of them didn't come into that job understanding that, so they had whatever belief they had and often set up expectations that weren't realistic. And so mutual education is so critical on any interprofessional team or interagency team. Establishing that relationship and really sustaining and building the rapport shows up as having its greatest value during the tough cases. The tough cases are that famous line of 20% of your difficult cases, 20% of your cases take 80% of your time. And that ends up being really true within APS. There are just some really difficult ones. And when those come, everybody is struggling, and almost everybody is anxious and pressed to practice in ways that are not easy. These are the cases that take more of your time and have more conflict involved. So you need trust across agencies if you're going to not carp at each other or break down into silos again and really sustain a true integration or a true collaboration. So we established point persons in each agency to work out those rubs, and they were different people. For the records process, it was a different person sometimes than it was for the consent process or the feedback process on findings. We also worked hard on improving the efficiency of our own evaluation process. We know how to do the Cadillac, but we can't always do the Cadillac. And so we worked really hard to develop some decisional algorithms for the scope of testing that would be required for different types of referrals so that we could do the most efficient approach possible. We automated all of our test scoring programs, built templates for report structures that then could be tailored for individual reporting. And finally, we addressed the ongoing location dilemma. Do you do this evaluation in situ or in the office? This is pre-COVID, of course. The in situ evaluation offers some options for direct observations and critical pieces about the living environment and the ability to do activities of daily living, instrumental and basic, in that environment, safety risks. So that information is needed from somewhere. Sometimes it's available from APS or another agency, but sometimes it's really helpful for the evaluator to be in that site doing it hands-on, and yet you need to do testing. So that in situ evaluation is also challenging. There's not only the time and effort, but it's very difficult to get adequate space and seating and lighting and privacy to meet the standardized testing assumptions involved in scoring standardized tests. The clinic also has its challenges. It meets the conditions for standardized tests, but you miss out on that in situ information. And furthermore, as I've said, it has to be seriously adapted for the clientele in this population. Oops, my final one, altering the front office protocols. We spent a huge amount of time on this. The screening time, the scheduling time, the pieces I've mentioned before. Honestly, if you don't do this, the process will fall apart because, again, the rubs will come up. So very briefly, the outcomes. We delivered a lot of services, and we were able to demonstrate that we did actually increase knowledge, and we being, I represent the people on the evaluator side, the referral provider's knowledge of capacity evaluations grew substantially. So just look at the darker purple colors in the before and after on the purpose of capacity evals, the types of evaluations, how they're conducted, the language in the reports, how to interpret them, how to use those report findings, really substantial increases in understanding on the side of APS caseworkers after this project was completed. So I would just conclude by making sort of the obvious observation that effective partnership requires a lot more than referral. So similarly, building an evaluation workforce is a really substantial challenge that's rarely addressed in formal training settings, in doctoral programs or even postdocs, because people are being trained to usually diagnose in more of a meta model than they are in the to apply it into the legal setting. And there's just some really urgent policy solutions around payment issues to meet this need. So I also share some references, and then I'll happy to receive questions, and appreciate the opportunity to share these findings with you.
Thank you, Sara. This was both George and Sara's presentations were just wonderful, and I thank you so much for sharing your information and insights with us. We have a number of questions. I have my own, but I'll get to the audience questions first. And one of the first ones that came in is, do social workers do these evaluations in North Carolina, and I would say in Colorado as well?
So North Carolina, when I started practicing, this is about 20 years ago or so, some of the attorneys that I worked with, when they saw my report, again called a multidisciplinary report, asked where was the social work, where was the medical exam. So I think at one point they did used to do them in North Carolina, and they were court ordered, but now it's, as far as I know, and we're doing more in Mecklenburg County than anywhere else, it's just psychologists.
Okay. And Sarah?
In Colorado, I think it varies in part by what the expectation is of the probate judge, but the standards, the universal, the probate standards that have been established within the field of law require that there be evidence of an etiology for the problem, documentation of the different domains of functional difficulty, and evidence of efforts to ameliorate those with any kind of prosthetic that can be included. So it's very difficult to do this evaluation and to meet those standards without having a pretty robust evaluation that involves cognition as well as functional assessment. Different people do those assessments. The functional component, I think the cognitive component is usually done by someone with training in neuropsychological functioning.
Yeah, and if I could just add one point, even when I'm doing an exam as a psychologist, even though other folks aren't doing exams, I still have access to social work data, medical data.
Mm-hmm.
I might have information from PT or OT that's very relevant for activities of daily living. So even though the social worker, him or herself, might not do the exam, I might have that data to use as I write up my report.
So a related
I would suggest it's almost critical to have data from multiple sources. I think you're exactly right.
And a related question to that, I'm skipping one question. Do you know of any case where guardianship has been awarded where there's been a capacity assessment evaluation done by a speech pathologist?
Is that to me or?
It's again to either.
Well, what I would say is, so one thing to keep in mind, and I didn't really have time to talk about this, in many cases where I practice, there's no formal capacity examination done. In fact, only about 10% of the cases where I practice does the judge order a capacity examination. So in those other cases, there's either no information or there's information from a therapist, a physician, a PT, an OT, whatever, about capacity. And I haven't seen those because I don't get referred those, but I think those are the cases where it's really, really clear about whether someone's competent or not. So, you look at young people with moderate to severe intellectual disability, older folks with moderate to severe dementia, those don't go out to an exam. So I think in those cases you can have briefer, it's really not even an exam, it's really just a letter or an opinion from a physician or whoever about the person.
Okay. So then we have a question, the APS department, suggesting that the APS department is able to acquire the records that you need for the evaluation. I think, Sarah, you were mentioning that you were having trouble getting, the evaluator was having trouble getting records. Might the APS caseworker get those records for the evaluator?
Absolutely.
Okay.
With client consent, as long as the client, prior to the assessment, the client is usually deemed with capacity, so they're their own legal decision maker. Once in a while, there's a medical POA that's been activated so that there's someone else to go to get the records. But that became a piece of the process, was trying to work together to find the most efficient way to get records in every case.
Okay. So we have a number of questions about remote assessments. Do either of you have any experience with or any thoughts about doing capacity capacity assessments remotely?
Well, I do now.
Yeah.
So I was off, like most people, for several months earlier this year, and the courts, actually the courts where I practice, the special proceedings court that does capacity exams, did stay open. It was one of the few courts that stayed open because of the importance of this kind of work in protecting vulnerable adults. And when I started back, when I was seeing folks, what I would do is I would do the interview remotely and really shorten the testing. So I was maybe spending an hour with folks in person, and maybe I'd spend 2 hours before. So I do interviews remotely now. I don't do testing remotely, although people are doing that, and that's what some folks are doing.
Yeah, and we have some in the chat. Some people are talking about that. Please go ahead, Sarah.
In our clinic, they've broken it up into sort of 3 segments post-COVID. One segment are the interviews with the potential ward, I guess, in a guardianship case, but the patient and a collateral. A second section is the section where they do a bit of remote cognitive assessment on tests that have been validated to be administered in that way. And then the third segment is in office brief segment. They try to keep it to a limited time period, and they've got a million protocols to handle in the office to handle having patients on site. We're in a building that has medical clinics also, so we're very cautious about bringing any older adult who's at risk on site unless we have to.
And I was just going to mention that I know John Halfin has been responding in the chat box, and we have a webinar with featuring him and some other people doing capacity assessments, but I know his is remote in Texas, so that would be a resource for people interested in that, because I'm going to move on. Related to that issue, do you ever do assessments in the home? It sounds like both of you, the older adults coming to the clinic, do you go to their home to do the assessment?
I went first last time. Do you want to go, Sarah?
Under some conditions, yes. We do go in the home or at the bedside. We do assessments in the rehab hospital or a contractor there, or in some long-term care facilities, although not now because of Colorado's rules under COVID. But we try to limit that.
Yeah, and prior to COVID, I would, and some of the other evaluators here would go out to other places other than our offices. For me, it was really if someone if it was extraordinarily difficult for someone to get to me, I would go to the home. But usually I did not.
Okay. And then we have a question about doing a capacity assessment with somebody who is legally blind or hearing impaired. Would you do anything different in your capacity assessment for clients that might have those conditions?
Sure, I'll go first on this one. So with hearing impaired folks, I have worked with interpreters, sign language interpreters, if needed. I haven't done an examination on someone who's blind, but real recently, but I have in the past, and I do think you have to alter your battery, the kind of measures that you administer. You have to have a sensitivity about what expectations are, what their home will look like, what modifications will look like. So I have done it, and you do, I'm not an expert on visually impaired folks, and actually when I have done them, I have consulted with folks that know more. But you do have to, I think, get up to speed a little bit on the unique conditions and issues facing those folks and hearing impaired folks.
That's what I understand from the evaluators in our clinic as well, is that you really need to know pretty deeply what the validation of your test is for people with hearing, vision, apraxias, mobility problems, tremors, et cetera, that are typical with older adults. And so there are tests that have been validated, and there are tests that we don't know much about it. And so you can use it for clinical observation, but you can't really use the norms. So it requires some specific norms.
Okay. I'm going to combine one of mine with a question that one of the audience members wrote in. But so you have to obtain consent for an older adult before you do capacity assessments, and the audience member was wondering, do you know anything about that? How many refuse? You know, can you say anything about those who about the consent process and who refuses?
George, why don't you start?
Oh, you give me all the hard ones over here. Well, so this actually, so remember, where I'm practicing, I'm working with the court, and the respondent now, the person who's allegedly incompetent, has a court order to undergo the competency exam. So they've been ordered by the judge to see me. So in that case, they're not really giving informed consent. It's more about assenting to the process. So I try and help them understand what the examination entails, what are the consequences, where does the report go, and so on. APA, if you read American Psychological Association, if you read their ethics, they've done a bit about this, working with either incompetent or potentially incompetent folks, and the ethical issues and how to manage that. And I would just say this is really different than a clinical referral because they've been ordered to come to you. Mm-hmm. So I'm having them assent rather than getting informed consent. Occasionally people have refused, even with the assent. And, you know, to be honest with you, that when you have to go back to the judge and say, you ordered this, but they refused, I try and tell them that that's not going to look really good for your, you know, if you want to be competent, if you want to get restored or so on.
In our setting, because it's a broader range of referral sources, there are times that consent is required, and then there are times when it's court-ordered, and it can be assent. And as George says, I mean, you're ultimately trying to cajole someone into trying their best on something that they're really sometimes angry at participating in. And it takes pretty advanced clinical skills to maintain the standardization of the test administration while you gather the information that you need from someone who may be uncooperative or resisting. And if they have great skills, the numbers are low. And yes, people can refuse to consent or assent, depending on which is the relevant process.
So related to that, do either of you have any thoughts on the impact that a capacity assessment has on an older adult, like this process, in terms of their well-being, and any thoughts about that?
Well, I can jump in there. I think it varies tremendously. It varies in great part based on the older adult's ability to understand the scope and evidence of their deficits. If they're aware of their deficits and they are afraid of losing independence, you have a much better shot at cajoling them and educating them and guiding them to appreciate that maybe it's a little bit bigger than you thought it was, and we're going to try to support as much independence as possible here, because that's the goal always. And you need some help. When the person really lacks ability to see accurately their own functioning, then it gets a little bit trickier.
Okay, so I have 2 minutes, and I want to make sure I get one question in. This is to Dr. Demakis. What was the length, depth, and, in your opinion, quality of the assessment documentation in the court files of the cases that you examined?
Mm-hmm.
Yeah.
Well, if you remember, well, if they were my reports, they were perfect. No, just joking on that. Well, so I think overall pretty good, because there's some variability, of course, but overall you have to remember that the county, it's court ordered, the county is paying the examiner a flat rate for the exam, and that it's a decent amount of money and they have a decent amount of time to do what they need to do. So based on that, the files that we've looked at are reasonably good in the sense that there's a thorough interview, there's collaterals, there's medical history, there's testing, and other things too. So one of the reports I just read from a colleague was 16 pages. And I'm like, that's way too long. I mean, why does it take 6 pages? But 16 pages. But my reports tend to be about 7 pages. So, you know, I think we're kind of unique here because we have the time and the financial support to really do a good job. So what I'm seeing is good. But remember, these are only a small percentage of cases go to the MDE. Many of them never have an exam, or if they do have one, it's like a one-line thing from the doctor.
Okay. So I see it's 3 o'clock. I could talk for hours about this, but we are done for the day. So I want to thank Sara and George for enlightening us today, and I hope that